Hello everyone and welcome back. In this video I'm going to talk to you about why a Baker Act, specifically a Baker Act placement hearing, is almost identical to the type of trial you might see in a criminal case. So when I was in the last semester of law school here in South Florida, I didn't have any class on Friday, and seeing as how I wanted to be a trial lawyer and I wanted to go back to the state attorney's office to be a prosecutor and get tons of trial experience, I used to go down to the Broward County Courthouse on a Friday, and I would find a really, interesting case to watch where there was a jury trial going on. It might be a criminal case, it might be a civil case, but the ones that I really enjoyed watching were the criminal cases because, well, I was going to be a prosecutor, so I wanted to watch other really, really good prosecutors doing their thing, and I learned a lot, and it made me a better trial lawyer. But, just to lay the groundwork here, because it was a criminal case, I could walk into pretty much any courtroom I wanted to unless there was something specifically that the court had said, okay, this is not open to the public. But as a general rule, you can walk into any courtroom anywhere in the country and watch a criminal case. And so I used to do that. And then on one side of the courtroom, there would be the prosecutor. On the other side, there would be the defense attorney, which may be private counsel or public defender if there was court-appointed counsel. There'd be a judge. And there may or may not be a jury because, you don't have to have a jury trial. You could have a trial by judge. So that's the criminal case. Now, in a placement hearing, which is where the state of Florida, because remember, the Baker Act is not a treatment statute. It's a statute where the state of Florida has grabbed your loved one and taken custody of them and made them a ward of the state, just like in a criminal case, except they're being prosecuted criminally as opposed to civilly. In a placement hearing, which typically takes place, not always, but most of the time it's going to take place in the actual Baker Act facility. And if it's not there, it's going to take place in the judge's chambers or the magistrate's chambers. It's going to be just like a criminal case, except for one very important thing. This is a confidential proceeding, which means neither me or anybody else, whether a lawyer or not a lawyer, is allowed to walk in and watch these things. They are confidential, strictly confidential. And that means it's not open to the public. But just like in that criminal case that I described, that I would go watch on a Friday afternoon when I was in law school, there's a prosecutor. There's either a public defender or court-appointed counsel, and there's either a judge or a general magistrate, sort of a junior judge, as it were. There's no jury. So it's going to be the judge or the general magistrate that hears the case. And the only real difference is the burden of proof. In a criminal case, it's beyond a reasonable doubt. That's the state's burden in a criminal case. And in a Baker Act proceeding, it's clear and convincing evidence. That's the state's burden, which is much lower, which means, ironically, it's much easier for someone to get detained in a Baker Act proceeding than it is in a criminal case. Think about that. How crazy is that? Your loved one is not a criminal. They've done nothing wrong. At worst, they have some type of mental health crisis that they're dealing with, and the state has a much lower burden of proof. No one can go and watch this thing. And sometimes these hearings are done without the family even knowing about it. I've had cases where we were called after the fact where the proceeding took place and the court-appointed counsel, the public defender, told the court that that their client, the respondent, was waiving their presence and did the hearing even without the client being present. Think about that. That to me is pure insanity, but that is the way the system is set up. It's draconian and broken, and it's not fair. But that's how this thing works. I'm sorry to say, which is why, if you have watched any of my other videos about the Baker Act, I am really adamant about the fact that the minute your loved one gets detained, whether they meet criteria or don't meet criteria, you should be fighting to get them out. Because as soon as they're Baker Acted, your right to make decisions for them, whether you have a healthcare proxy or a power of attorney, are terminated. It doesn't matter. It doesn't matter what you have. The state's right to take your loved one trumps any authority you think you have been given. And your loved one's right to make decisions for themselves, that's been terminated too. The state's right to detain your loved one is the ultimate power in the situation, which is why you must fight as soon as they have been detained to get them out. If you don't, then unfortunately sometimes the case can go south and you suffer the consequences of waiting and waiting and waiting. Does that mean that every case goes south? No, some people do get released. Sometimes it happens within the 72 hours, and sometimes it's a week, or 2 weeks, or 3 weeks, or a month, or a couple of months. My point is you shouldn't wait. Why take the chance? You shouldn't take the chance. In any event, I wanted to share that with you. I think that a Baker Act proceeding is frankly far worse than a criminal case. I really do. And anyway, I hope you liked the video. I'd love a thumbs up. Please subscribe to the channel, and I'll see you in the next video. Bye-bye.